Maintainability or entertainability?
Entertainable.
Review is maintainable.
Yes, review is maintainable, but can it be entertained on the grounds that I have made? To answer that, I will take your lordship to the ground on which, one of the principal grounds on which I am raising this application for review is new facts which have come to the notice of the appellant post disposal of the writ appeal, my lords. My lord, to show that, your lordship may kindly see page 15 of IA number 351 of 25. It's at flag C, my lords.
Page
15 of IA number 351 of 25. IA number 351 of 25 is
Answer 1. Answer 1 to
Annexure 1. Annexure 1.
IA 351.
Yes, my lords. Now, if your lordship sees that's a notification of the government of Orissa. Kindly see the date, my lords. So this is the 24th of January.
when it is notified.
Sorry, my lord.
When it is notified.
24th of January 2024. And my lords, here, your lordship, this is
Yes.
now if your lordship takes at page 17, Odisha Procurement Preference Policy for Micro and Small Manufacturing Enterprises 2023 MSME Department Notification. Now, your lordship may come to page 18. Page 18, column 4. This policy will, however, not be applicable to procurement of services, including works contracts. Now, this, my lords, has again been reiterated in 2025, March 2025, which your lordships will get at page 28. Now, my lords, what is the meaning? By the virtue of these notification, works contract goes beyond the purview of adjudication under the MSME, my lords. Now, my lords, your lordship will see what is the nature of work which was entrusted to me.
Yes.
Yes, sir.
sir.
Now, what was the work which was entrusted to me? That has been extracted in paragraph 4 of the appeal judgment. If your lordship takes at page 28 of the brief, review petition, page 28. Page 28, second
Yes.
line. The work order was for fabrication, erection, and painting, etc., of structural steel work in connection with power plant area. Now, if your lordship sees definition of a works contract, which is in section 2, subclause 119 of the CGST Act. It says works contract means a contract for building, construction, fabrication, completion, erection, installation, fitting out, improvement, modification, repair, maintenance, renovation, alteration.
Whatever, the court has also held it is a work contract. Then,
Now, my lords, if it is a works contract,
true. Then the scheme according to you is excluded.
excluded. Now, if it is excluded from the purview of the MSME Act,
Now, question is why you did not place that particular scheme before the court?
my lord, the scheme, my lords,
You are referring 24th January 2024.
now, works contract goes out of the scheme of MSME.
True.
It came into existence. The government notification came into existence after disposal of the writ appeal by the this honorable court.
No, sir. You are referring
Yes, well, it
to
was
page 15, 24th of January 2024 notification.
It came to my notice thereafter. It came into existence.
Now you have said that because you have to pass the muster of due diligence.
My lords, true, my lords. When it got reiterated, and now, my lords, it becomes even more fortified because now this honorable court has also taken cognizance of this.
Yesterday, I have dictated one judgment on the review.
Yes, my lord.
I say it's not meant for rehearing. It is not meant for
It's
revisitation.
This was
It is
new
not
point.
meant for revisitation of the case,
Yes, ma'am.
nor for rewriting of the judgment. I think my brother has corrected it. I have not seen that. Yesterday's judgment.
Well, my lords, may I just take your lordships to one of the latest, very recent judgment of the Honorable Supreme Court. It was delivered only in September 2025.
Shilpi is distinguished.
Sorry, madam.
Shilpi is distinguished.
Maleshwari judgment. We have also taken into consideration.
Yes, madam. In fact, your lordships way back in the judgment of the capital has the very same fact. Your lordship may kindly see paragraph 17
I've seen that.
at page 9. The grounds of discovery of new and important matters or evidence is a ground available if it is demonstrated that despite exercise of due diligence, this evidence was not within their knowledge.
This is what I said. These are the three parameters
Yes, madam.
of review under Order 47, Rule 1 of the Code of Civil Procedure. One is the error apparent on the face of the record. Second is discovery of new and important piece of the materials or a document which, despite the due diligence, was not within the knowledge of the applicant applying for review. And third one is for any other substantial cause
Correct,
or
ma'am.
reasons.
Madam,
So-
here in this case,
Yeah, discovery means then when you are talking about 24/1/2024 notification,
yes,
which promulgated a particular scheme, and the scheme provides that for the work contract, the MSME is taken out.
yes,
Then in that event, your contention in the review is that the learned judge has wrongly held.
no, not wrongly held. This was a new fact which I
Sir,
have
wrongly
brought to the notice
held
of the
that-
review court. I had not brought it
Let
to
us
the notice of the
let us have. I think the English is a foreign language. Everybody has a different way of expressing it. So what I perceived, now I am reframing my sentence. What I perceived from your argument is that the learned judges have committed an error in holding that the MSME Act has its application and you have to go to the arbitration. Your contention is that once the MSME Act is kept outside the purview of these work contracts, then this particular decision contains an error, which is patent. Question is that when you rely upon this particular notification of 24/1, which was in existence on the day when the impugned judgment was passed, then you'll have to satisfy that why it was not within your knowledge, when it came to your knowledge, what in due diligence you have done. Despite such due diligence, you could not get that particular documents. All these things have to be pleaded. It cannot be said to be an error apparent on the face of the record.
But fact remains that there was a notification of the government of Orissa in January 2024. Now, the notification once made does not come to the notice of one and
Where
all.
is the pleading, sir? Show us from your review application. You have to make out a case. You have to plead it. Where you have pleaded that you made all efforts to find out it was not within your knowledge, nor it was ever shown the light of the day. All these things you'll have to bring it. Where is the pleading?
I can bring that by way of an affidavit. I can bring that by way of...
Why, when the court is putting a question,
No. What
very, very, very casual way of drafting a review petition.
what is perhaps the purport or the import of this notification took time to sink in to the people, even the MSME.
Sir, these are the cases. This case is made out at the bar. You know the importance of pleading.
Yes,
That whether the court will permit any fact to be brought on record or taken into consideration without any foundation in the pleading.
Well, in that case, may I just take your lordships to the case of Associated Cement, where, my lords, the court has said in paragraph 3, they say, by this petition, it has been pleaded that
That
inadequate.
is what I say, pleaded. How it is to be pleaded. There must be some averment. I am
That-
drawing your attention to this. The word pleaded means what? Not argued. Pleaded means it is.
It has to be there on the record. But what was pleaded and what was argued is the inapplicability of the.
True. Now the court, on the basis of a Shanti's judgment, on the basis of the other judgments, have taken a particular view
Yes, my lords.
that even the definition under section 2N has undergone a sea change. Yet the principles which is laid down in that Shanti applies, and it does not take away outside the purview of the MSME. The question was that whether this MSME Act, whether it applies or not, depends upon the day when the contract is entered into, or an order is placed, or what. Everything was considered in
No,
this judgment.
what was not considered, or very importantly, it was not which has been overlooked by the court, is irrespective of the fact that you become a supplier by definition of the MSME Act, it has to be brought to the notice of the buyer. If you don't bring it to the notice of the buyer, you cannot claim the benefits of the Act.
Now, suppose now there another question that comes. I am again on the jurisdiction, Mr.
Yes.
Mukherjee.
Yes, yes, ma'am.
Jurisdiction. Suppose a point has not been considered. We do not know whether it was raised or it was not raised. It does not appear from the impugned judgment that this point was ever raised. Whether this invites a court to review its judgment.
Well, it has been very categorically raised that
Where there is nothing.
No, I'll show to your lordship.
There is nothing, sir. There is nothing which comes.
Yes, my lord. Now, my lords, admittedly, from the facts borne out from the record, the last purchase order.
That is what you are drawing a logical inference.
No,
you are drawing a factual inference.
I'm not drawing any inference. What I'm submitting is from the records.
This is true, which can be logically deduced.
Yes, it can be.
Can the review?
No, my lord.
What can be logically deduced can the review lie?
No, my lord. It was pleaded that.
But not argued. There is no reference in the judgment.
If your lordship sees the judgment also, in fact, the court has, if your lordship takes paragraph.
Yes, it is difficult. We will rely on these judgments, and these judgments are also pointed to the issues. In absence of any categorical pleading, that cannot be done in this.
Now, if your lordship sees paragraph 9, this was brought to the notice of the court.
It was which one? The judgment
of the appellate, the impugned judgment, appellate court judgment.
Yes.
Page 33.
Yes.
The learned single judge following the decision on the case.
Paragraph
9.
Yes.
The learned single judge.
Vaishnav Enterprises was there, caused the MSME on the ground.
Mainly on the ground.
That he has not obtained registration 5 years after.
Yes.
Obtained registration 5 years after.
5 years after. And what was missed out is that this was after the last purchase order had been issued. Now, my lords, what is important is what flows from the statute. Kindly see, my lords. Section 21 and 22 of the statute. 22, sorry, ma'am. Section.
Sir, these are the things what transpired to the appellate court from the judgment of the single bench. That is what, it's not a case that you have argued. It is what the learned judges, they gathered from the judgment of the single bench.
My lord, if I had not argued that,
Then-
would the single judge have addressed it, my lord?
No. Why should?
I had argued it. That is
Where
exactly
is the
reason why
case that you have argued?
reported it.
No, where is the case that you have argued?
But this is otherwise.
Because
This is
the difficulty, I tell you, there are multiple points. In usual course, you are very veteran in the profession. You are aware from your experiences. When a judgment is sustained before the appellate court, at times it so happened that the counsel for the appellate restricts his argument on one point or 2 points and does not argue on the other points.
my lord,
If he abandons and did not argue, then the points which is argued by him before the court, if the court has dealt with those, can we say that it is absolutely an error apparent on the face of the record because
my lord, I'll make
these
a submission.
points were taken? You may have abandoned your points.
My lord, I'll make a submission for your lordship's consideration. I have 10 points which I've raised in a
Where? That is what is there.
I've raised
I
10
understand that you raised 10 points
Yes, ma'am.
before the court.
I
The
argued point
the
number
court
one
did
and
not
two.
did not consider 2 points.
No, my
only
lords,
considered 8 points.
Kindly allow me to
Understood.
complete, my lords. Kindly
Yes.
allow me to complete. My lords, I have raised 10 points.
Yes.
I argue point number 1, the court finds that point number 1 vindicates my case and proceeds and delivers the judgment on allowing my case on point number 1 alone. There is no occasion for me to argue point number 2 to 10.
You are before a civil judge. I am conscious of Order 14, Rule 2.
My lords, if I have raised the point.
I am conscious of Order 14, Rule 2.
Yes, my lords.
If there are several issues, if one issue decides the case,
Yes.
finally, then the court need not have to go to the other issue and answers.
Correct.
Take, for example, there are 5 issues. Primary issue is the issue of, say, res judicata or a limitation. The court found and held that it is barred by limitation. He did not have to venture upon the other issues on merit
Absolutely.
because the limitation itself is a ground where you can
Then the
throw.
proceeding goes.
If it is a res judicata, it's still a ground to deny that it is not maintainable.
Yeah.
I am conscious. The issue must be of such magnitude.
Yes, my lord. See, this is of that magnitude.
Now, only thing is, that is what I'm saying. Those principles stands on a different footing than this. Here, what you argued was considered on merit. The court has arrived at the decision based upon certain judgments. Your contention is that these judgments, yes, those were there. There's no doubt about it. But by virtue of a change of law, by virtue of certain things, this judgment is inapplicable. This makes the judgment erroneous. It is an erroneous judgment. Let us go to the greatest of height. We can say it is an erroneous judgment. If it is an erroneous judgment, whether such judgment is amenable to be reviewed.
No, my lords, I will not venture into that part of the argument. What I am trying to say here is this. What I argued in the writ petition is inapplicability. The proceeding was not maintainable against me because you were registered as a supplier under the Act post my entrusting the work to you, and this fact was never known to me. Now,
So
this
where
fact,
is again I'm going back, where is a pleading that
yes,
it
my lord,
was
that
not?
pleading is very much there in the writ petition, my lord.
Please, not writ petition, in the
Writ
review
petition, my
petition.
lord.
In the review petition.
You know, in the review petition. I'll do that. I'll do it. Well, will your lordship grant me one passover? I'll just find out from the ground and come back to your lordship. I think I've seen it. I'll just find out which ground it is without arresting your lordship's time. I'll just find out. Just one pass over here.
At it, the way you have drafted the review petition. I simply draw your attention to paragraph 11 and 12. That's the only pleading you have done.
Here, my lords, in paragraph
In the review petition.
paragraph 8C, my lords, of the review petition.
No, 8C is a reflection of the fact it does not make out a case for review. Please.
Not very happily worded, but that was the intention.
No,
what was
please,
thought to be
please.
put forth before the
That's why I'm saying that sometimes you were not an arguing counsel. You do not know the arguing counsel may have abundance, say if he has taken a grounds from ranging from A to H, as it's appearing in paragraph 8.
Yes, sir.
And if he has abandoned any of the grounds and did not address the court, do you think that it's a
My lords,
blatant error? It's a conscious decision of the counsel to argue a point. He may think some of the points not relevant. He may abandon it.
No, the position of abandoning doesn't.
The difficulty is that it is coming from a senior counsel who was not there to argue.
No, the grounds are there. He had
Again,
argued.
that's why I am thankful. I am thankful that there is a live streaming. One can now definitely say whether it was argued or not. It's very easy to say on affidavit that it was argued.
And go to the extent of saying he may not have argued this point. He may not.
So that is what I'm saying. And then,
but
what are the grounds for review?
No,
please.
My ground is this, my lord. My ground is this, my lord. What was argued in the writ petition were certain grounds which found favor with the petitioner, with the court, and the petitioner's writ petition was allowed. Now, my lord, it may have so happened that at that point of time, the council had 6 other points which are set forth in paragraph 8 of the review petition. These were the grounds which were raised, but the court allowed it on a particular point. The other points were not required to be addressed. Now, my lords, when judgment goes against me in appeal, it was reversed in appeal. I raised this in review, my lords, because these were already there in existence. It's not something that I've picked out of thin air now. This ground was very much there in the writ petition. Pleading was available. What I'm arguing is just a proposition of law that merely because as a buyer, there are certain obligations which are cast upon the buyer under the statute, which your lordships will get at page under section 2022 of the MSME Act. Because if I am doing business with a MSME unit, I am required under law to do certain acts. Now, if I am not even aware, after I issue the last purchase order, there is a change in status of the supplier, and I am not aware of this. There, my lords, the date of supply becomes immaterial. That is the error apparent on the face of the record. That is the error, my lords, which I wanted to point out to your lordship. Date of supply becomes immaterial if the fact that the supplier is a MSME unit is not communicated to the buyer. And this, my lords, there is one judgment of the Gujarat High Court on this point. If your lordship will kindly see, my lords, this judgment. My lord, take page 10 of the decision.
Of course,
Your Lordship may take at page 8 of that judgment, paragraph 16. As your Lordship, Lord. The moot question that therefore arises. May I read?
Yes.
The moot question that therefore arises is whether the appellant is a supplier as contemplated under section 2N of the MSMED Act. The next question that arises for consideration is as to at what point of time the memorandum should have been filed by the micro and small enterprise to be eligible to make a reference under section 18 of the MSMED Act, namely whether such memorandum should have been filed before the supply is made or at any point of time even after the contract is executed. In this regard, the scheme of Chapter 5 of the MSMED Act may be revisited. Section 15 of the MSMED Act provides that a buyer shall make payment for any supply of goods or services rendered by the supplier on or before the date agreed upon between them in writing, and in absence of an agreement before the appointed date is defined under clause B of section 2 of the MSMED Act to mean the day following immediately after the expiry. Your Lordship may skip over all that. Kindly come to the quotation to para 52. That is the last paragraph of the page. The proviso to section 15 of the MSMED Act provides that in no case the period agreed upon between the supplier and the buyer in writing shall exceed 45 days from the date of acceptance or the date of deemed acceptance, where the status of the enterprise, whether it is a micro enterprise or small enterprise, is determined by filing of a memorandum by such enterprise with the authority referred to in subsection 1 of section 8 of the MSMED Act. The parties would be aware that the provisions of section 15 that Act have to be complied within the time provided thereunder. Moreover, in the absence of the status of the enterprise being determined, the agreement between the parties would not be in terms of section 15 of the MSMED Act. Next page, Maharaj. Adverting to section 16 of the MSMED Act, it is onerous provision which casts an obligation upon a buyer who purchases goods from a supplier in case of non-payment of the amount as required under section 15 of the supplier to pay compound interest with monthly rates to the supplier on the amount from the appointed date or the date immediately following the date agreed upon at 3 times of the bank rate notified by the Reserve Bank. Therefore, before a buyer purchases goods or avails services from a micro or small enterprises, he should be aware about the status of the enterprise so that he knows that non-payment of the amount within the time provided under section 15 of the Act will entail payment of compound interest at 3 times of the bank rate notified by the Reserve Bank. Moreover, section 22 of the MSMED Act casts an obligation upon the buyer who is required to get his annual accounts audited under any law for the time being in force to furnish additional information as stipulated therein, failure of which would be visited by penalty under section 27 thereof. Moreover, in view of the provisions of section 23 of the MSMED Act, the buyer would not be entitled to claim deduction of the amount payable or pay by way of interest under section 16 of the purposes of computation of the income under the Income Tax Act 1961. Therefore, when such onerous obligations are cast upon the buyer under the above provisions of the MSMED Act, the buyer should be aware of the status of the enterprise from which he is purchasing the goods or availing services, whether it is a micro or small enterprise. It therefore appears that the legislature has intentionally provided for the purposes availing the benefit of the provision of Chapter 5 of the MSMED Act, a micro or small enterprise should have filed a memorandum as contemplated under subsection 1 of section 8 of the MSMED Act and accordingly has employed the expression supplier in section 15 so and so and so. So, my lords, here is a case where
Yes.
entity. That entity is not a MSME unit.
Come to Abukar.
during incumbency of the contract, he surreptitiously obtains a registration behind my back without my knowledge,
First is
thereby creating a onerous obligation upon me.
Come to paragraph 11 first. What was the argument which was advanced?
Registering the solution.
Yes. You got that? That was the now come to this.
Next 12.
No, not next one. You come to this.
Manoj, as far as
Paragraph
present
21.
opposite party is concerned, he has made a habit of encashing on the MSMED. In another proceeding, he had gone up before the MSMED and this honorable court in a very recent judgment.
With all humility, my lord, just do castigating crime.
That's
what
quoted from a judgment of this honorable court. You have made it a habit of going there and pinning people down.
Between 21 you have read. And
22-1. That is the finding. 22-1 is the finding.
this is what it means.
That's not the, and so based on which was
I think, Mr. Mukherjee,
Yes, Prabhu.
sometimes we have to close the case.
What cost? Well, your lordship may kindly see page 11 of
Sorry,
the
whatever you are arguing on the merit, you are arguing only on the thing, which cannot be done in a review jurisdiction.
My lords, in that case,
We can't. And the point which we are taking that you were not intimated, let us reflect in the judgment what we logically deduce from the impugned judgment, whether this point was taken into account. Though we say there is no pleading on that in this regard.
my lords, may I make a submission here, my lord? My lord, the point which I am raising, a few questions of law, and it's a question of there being pleading appropriately made or not made. My lords, may I seek your lordship?
No leave to file further affidavit.
No, not affidavit. My lords, if the only thing that I would request your lordship to consider is whether I should amend my writ application, seek
Same thing.
leave to amend my
Same
writ
thing,
petition
same
and
thing.
argue that
At
writ
the time of
application-
an argument, so
Sorry,
that is at the time of an argument, though not in stricto sensu, the proviso to Order 6 Rule 17 applies, but the principles can be borrowed therefrom.
can be borrowed, my lords, but here
In
is a
2002,
case-
what was the purpose? What was the purpose of bringing an amendment in Order 6 Rule 17?
Yes, my lords, amendment has been brought in, my lords. Each day it is receiving the
No, why Malimat Committee recommended this proviso to be inserted under Order 6 Rule 17? To avoid these kind of a things, that even at the stage of an argument, even at the stage of the hearing, after sensing that a plea has been taken by the defendant, then immediately the amendment applications are taken out.
if it is
Then,
backed by
then-
law,
then-
my lords, if
then,
it is backed by
then-
law
then-
or facts which
Please,
have
then
come into effect.
Malimat Committee says that this really protract the litigation.
Could be,
And
my lord.
therefore, one has to satisfy that once the trial begins or commenced, why he did not take out an application prior to the commencement of a trial. So here, because I believe interaction being one of the facet of a fairness and a transparency in adjudication process. So I always express my mind that what is really troubling me. But that does not be taken in that sense that it will, now I will improve my case, I will bring by way of amendment, now I will bring by way of this.
As far as the pleading is concerned, that I wanted to show to you.
Oh, anyhow, you have taken a plea, you were not intimated. Let us see that whether you were intimated or not intimated.
Your Lordship may see the ground.
I have seen ground J.
No, firstly, Your Lordship may see ground B with regard to works contract.
That has been decided by them. No difficulty. One way or another.
Sorry, my lord?
One way or another, they have decided it.
Works contract. They have not addressed it, my lord.
It's the paragraph they have said it's the work contract which is there, and thereafter he continue.
But my lord, the notification has not been taken note of.
Sir, notification was not placed. It does not see the light of the day on when the judgment was delivered.
My lord,
and now when you are trying to bring it again, I said that where is the concept of due diligence? Even Justice Amanullah's judgment of the Supreme Court you are citing. The first ground is that the due diligence has to be complied with and satisfied. There is nothing. I have seen your petition. It's a very casual and may I use another bad expression? It's a cavalier way of drafting the petition.
Well, what is important is that these facts have been brought to Your Lordship.
No, sir. No, sir. We will go by the strict rules of pleading.
Your Lordship may.
We'll go by it. If you do not plead it, no, we will not permit.
What I propose to do is I will just prepare a short note and submit to Your Lordship.
I will record everything. We'll record everything.
Your Lordship, there are two other judgments which I would like to place. Your Lordship may take note of that and
please.
There is
but it cannot be no paragraphs.
just again show Your Lordship the judgment which I have placed, that is associated cement case. Your Lordship sees paragraph 4 of that judgment, last 4 lines, last 3 lines.
No, that one.
As section 112 was not brought to the notice of the court, the appeal of the revenue was dismissed. In view of this statutory provision, the appeal of the revenue could not have been dismissed since the assessee was not entitled to get the benefit of section.
That was the patent error, which is
yes, here the patent error.
He has interpreted. Sir, he has interpreted the provisions. It is not that it was not brought to his notice. Only thing is the scheme. He has considered all these sections which are there. The definition of a supplier.
No, he has not.
Yes.
It has not been considered.
Yes.
Section 219 of the CGST Act has not been considered.
Please consider what you argued.
Sorry,
Anyhow, sorry, since I interact more, then it invites more.
No, this is what I wanted to bring to your
Yes.
lordship notice, that this particular provision inadvertently was not brought to the notice of the court. There was no occasion for the court to consider this. I now, having brought it to the notice of the court, it can be brought up in review, and your lordship, that is my submission. That is my first submission.
Right.
This other submission with regard to my lords is that the notification of the government of Orissa was discovered by the petitioner post the disposal of the appeal. This is number two. Number three is, my lords, the knowledge that he became a supplier during incumbency of the contract, and that too after the last work order had been issued, was not within the knowledge, and hence he cannot claim benefits under the MSME Act. Number three. Number four is a recent judgment of our own High Court, which involves the very same opposite party. Very same opposite party, and a judgment is dated the 20th of September 2025. Here, my lords, a similar nature of the contract, this honorable court has held that it is a works contract and hence cannot be brought within the purview of the MSME Act. The very same party, my lords, very same opposite party. These are the 4 points that I am telling.
Uh, the You have not filed your affidavit, sir?
No, sir, my lord, sir, I've received the instructions. Just now, my lord, today morning I've received, I'm placing it before my lords. My lords will, I'll file an affidavit, my lords will give me some time.
A week.
Fine.
You file an affidavit within a week, rejoinder within.
Affidavit to file.
Item
He will
number,
give you a affidavit, don't worry. Rejoinder within a week. Put it after 2 weeks. Yes, 3.
item number 3.
To file. Digital. Time to file.
So this matter related to regularization of junior engineers under the lift irrigation corporation. Essentially, it is a single judge matter. In fact, single judge has entertained similar petitions.
Then why it has come
It
to
has
the
come here because of that tender notice for recruitment, engaging recruiting agency. So as a tender matter, it has come.
So your plight is if tender is finalized, then your case for regularization may not be considered.
Yes, ma'am.
I think on many occasions, lift irrigation corporation has been directed.
Who
by
is
this court,
appearing for the other side?
No, here notice has not gone.
Not
Fresh, ma'am.
Yes, give a notice. Returnable after 2 weeks.
Item number 4.
An interim order is here.
Or sir,
No,
come.
my lord, the single judge has.
No, you have filed petition for regularization that is pending.
For the authority.
No. Writ court.
This is a writ petition, my lord. It is not a writ appeal.
I
no,
understand, sir. Your case is of a regularization.
And
You have already applied for regularization.
continuing, and now a new recruiting agency is directed to sponsor names. And in fact, a single judge has entertained and granted interim orders.
In your case.
No, not in my case, in similar cases.
So in the similar case relating to this request of proposal,
Yes, ma'am.
so there is already an interim order operating. Why you are have a problem? No, come after 2 weeks. There cannot be multiple interim order. Either relegate to a single bench or let us decide. Come after 2 weeks.
Item number 4.
This matter, Lordship, the Excise Commissioner under Annex 3.
Item number
Wanted the
4.
proposal.
Yes.
And last opinion, the Lordship passed order on 17 days.
This matter was in fact disposed of, the lordship was supposed to pass orders direct to the government to dispose of the revision on the available materials. So, documents kindly see.
The present intervener has filed a.
Where is the decision on the revisional application?
And the instruction letter and the revision application has been fixed to today.
Today,
Yes.
matter to appear after a week. Let them come.
Well, I have not been noticed. Still,
Item number
Go there, now you are.
Ask
There.
the client to keep track over that. Now he is divulging that
I am
today is
also
the
very-
day.
today.
Let him.
My client is the revision petitioner. We have also not been noticed.
Item number 5.
Sir, give them a notice to all. Now give a instruction is there. Let them go today.
No, you are authority to ensure not to pass any expertise. He has to first ensure that it is served, notice is duly served and the parties concerned.
Today I got instruction, no notices.
So he is saying today it is fixed.
That's
How-
fine.
ask
We'll
You ask the clients
let them fix up a day.
Another day.
to have track over that. Otherwise, if he passes an order, it will become.
Because no notice has been.
Now you know
The
that.
revisionist also saying that I have not been noticed.
Now he is divulging that today this.
Okay.
Item number 5.
So what kind of a prayer I am unable to make head and tail from your prayer, sir. Sir, don't go by the annexure. Come to the prayer. Tell me if any person can make a head and tail from there. What do you want? Sorry, I am the last person. What is your right? Representation. What is your right? Tell us.
We are villagers.
Villagers means all the villagers have a paramount right.
Some people don't the ancestral plots in roadside. They are encouraged them. They are applied before the opposition, but not fair to encourage them. Only my limited time. I have already given representation before the opposite panel.
Millet, we have taken steps there on Millet after receiving the
Complaint from them, you have initiated a proceeding
Yes, Millet.
and the proceeding is going on.
Millet, inquiry is being conducted and the date is fixed to 14th Millet for demarcation regarding these persons they have imposed upon this part of the land. But
So you
Millet,
have already taken a steps.
Yes.
To us, we are disposing of the matter.
Millet, another thing, Millet, to apprise the lordship, the state government has taken a policy decision regarding zero tolerance of enforcement, Millet. And
Without delving into the
Item number 6.
Yes, please go. Here, the petition is a license of contradictory shop challenges the collector under annexure 2 directly shifting of the shop in violation of lordship's rule 33(2).
how can it be? Our judgment is against
Yes,
you, sir.
I have annexed the lordship judgment, annexure 3.
Oh.
Same, not the same.
Annexure 3.
Same collector.
A
Same.
judgment is a part of the annexure where is never done. You can cite the judgment as a precedent, nothing more than that.
They've said that.
Then what to do? Can't.
I'll only take instruction on that.
What instruction?
To explain. Thereafter.
Sir, you granted the license after taking into account all the factors
Just
which are required. What is only will only occupy a space in the docket, nothing more than that.
in the light of your lordship's judgment, we'll examine the case, my lord.
What examine the case? Have you not granted a license? Have you not directed him to shift the shop because you have subsequently received the objection? Such objections cannot be entertained at all. Then
But first time it is coming.
first time, that does not mean that automatic adjournment. So it's an open and shut case.
But
Then
at least.
no, nothing. Yes. Where is the communication of the collector to shift
Annexure 2, page 12.
page?
12, my lord.
He has received an objection.
Yes, my lord. This objection, your lordship, in the judgment under Annexure 3, same objection, same part. And the language of that in that case order, and this also same also.
Patents and other passers-by in the locality. What is this? Patents?
I also find
Inconvenience to patents.
patents word is there.
I do not know patents word. What does it? Parents or a patent? I do not.
That's spelling.
That is the public health unit.
Patient.
Present.
Spelling.
Present. Spelling mistake.
Brother, disposed of. In the light of that. Yes. No, disposed of. On the basis of this.
Item number 7.
They have cancelled the tender.
No, madam, till that it has not been cancelled, but the.
Fresh tender has been invited,
No.
that implies.
No, managing director has directed to go for fresh tender.
So,
Though the guideline doesn't stipulate for the same.
Why?
Our rate has been disclosed, thereafter a negotiation has been made, and we reduce our rate by 10 rupees again. Myself,
who is
the collector.
Is who is appearing? So you do not represent them.
No, man.
There is a separate
Separate, they have a panel.
issue notice. 2 weeks.
Your lordship, kindly have a glance to the last order, the 15th thing of this morning.
Only requested both sides.
My lord, while appearing, I have appeared for the appellate, not for the respondent. So, your lordship,
What?
on that day, I have appeared for the appellant for the. appellant in this
Yes,
case.
so
I have not appeared for the department. That may be considered, that may be ignored.
oh, I do not know.
This
RP Corp,
50.
So I have appeared for the appellant.
so that
And
is
not for
happening.
the department.
No, the
My name
department
has
is,
shown
No, it
as
is reflected as if he
Appeared
he
for the
usually appeared for the department, so it
Why
was
do not-
entered, huh?
I may have permitted to appear for the appellant.
It's something.
The matter of this case is that the appellant is a manufacturer of ferrochrome from ferrochrome slag. It is processing, it is extracting the ferrochrome from the ferrochrome slag. That has been contained as
a manufacturing activity by the adjudicating authority. And the appellant went to the tribunal, and the tribunal only on two grounds, that is, these two items, that is ferrochrome slag and ferrochrome, coming under two different chapters and different headings. And by relying upon the decision of MP High Court, which has been confirmed by the Honorable Supreme Court in the case of S.N. Sundaresan, he has confirmed the order. He partly allowed the order. So, my lord, my humble submission is that I've prepared a compilation for your lordship's convenience.
Question number D. Question number D.
Yes.
Classification.
Two relevant questions are there. Page 14, if your lordship see.
Ferrochrome is not akin to high carbon ferrochrome slag.
My lord.
They are not identical commodity or the different commodity, distinctive commodity.
Distinctive commodity.
Different commercial commodity.
Different entry value, different commercial commodity. While manufacturing ferrochrome,
Different chapters.
different chapter, different headings. While manufacturing ferrochrome, if your lordship will appreciate, some of the ferrochromes remains in the slag. That is the slag. And the appellant used to procure that one, used to cross that one, and used to wash that one, and extract those ferrochrome embedded with the slag. So that process cannot be treated as a manufacturing activity. Because ferrochrome, the composition, the chemical composition, as well as the physical condition of the ferrochrome have never been changed.
There is no change in characteristics of the original commodity.
No,
You mean to say that?
my lord.
Where is the judgment of the Supreme Court is
If your lordship will see my compilation, that judgment is totally not applicable in this case. It is page 72, start from page 72. And your lordship kindly have a glance to page 75. Last paragraph. The facts in that case is that the buyer has given order
There it is. Yes. 75, last paragraph. Such and such law officer of Messrs. S.N. Sundaresan Minerals Limited was examined, and his statement was recorded under section 14 of the Act by the Superintendent of Central Excise Salt Act on 31/8/99. In answer to questions, he has stated that the company is manufacturing limestone in particular site. Your lordship may mark this one. In particular site, by crossing the limestone into lime from lump from. According to him, the company purchases limestone in lump from or stone or excavate it from their mines and then process it by putting it into crusher machine to obtain the desired sizes of the limestone chips as per the requirement of the buyer. So here the fact is totally different, Miller. We are not manufacturing a particular size of ferrochrome from the
whatever. When you are using that particular the material, that only goes for crushing, grinding, and watering it. Nothing more than that.
Nothing.
Then in that event, what? The same thing is here.
Same thing, but here the Honorable Court has applied the twin test, my lord. It is the twin test as observed by the Honorable Supreme Court in the case of Delhi Club. I have already annexed that. That twin test is my lord.
It is a slag.
My lord.
Which you are using it for what purposes?
Slag is our raw material.
So, and what you make?
So ferrochrome slag, we are not extracting the ferrochrome embedded in that slag.
How you are extracting it?
By crossing and washing. By crossing and washing.
So the same thing is limestone. Limestone now is also used for crushing.
My
to
lord.
make it at different sizes.
But different size here, the main distinguishing
Does not-
factor in this case, your lordship will appreciate that there is a purchaser to supply a particular size to the purchaser. And they are
What
making,
the slag is, what is the slag?
my lord,
What is the slag?
my lord,
Slag is a lump.
it's a lump.
So, and then what you are making it,
We are just
crushing, when you are crushing it, are you not making it into a particular size?
No, Mila.
Or in a powder?
No, it's a particular size, but it is not constant Mila. It's not constant Mila. It may be 2 mm, it may be 4 mm, it may be 6 mm.
Sir, that's why is when you changes the size
My lord,
by using a crusher,
my lord.
then what does it mean? There are two types of crusher. One is that it will only crush it to a particular size,
My lord.
and one it crushes you in a after that manner in a different sizes.
Yes.
The object and the purpose is crushing.
Crushing.
Without diminishing that particular the total the chemical the compositions or the chemical characteristics of that particular act. This is what essence says that it does not when it changes. The only thing is it changes, then it comes within the purview of manufacturing. And then when you prepare the particular pipe or the final product,
My lord.
then if it comes under the different classification, then you are liable to.
My lord. The finding person, how the Honorable MP High Court has distinguished that matter is
Sir,
that
we
page
are
70.
concerned with the Supreme Court. We are not concerned with the High Court.
The Supreme Court has not considered the process of manufacturing. Your lordship, kindly see the Supreme Court order.
Is of a Supreme Court or is some other Pradesh? Okay. So,
Page 78 is the Supreme Court.
yes, where is the Supreme Court?
The Honorable Supreme Court has not considered the process of manufacturing. The Honorable
Yes,
Supreme
yes,
Court,
yes.
yes, please. Page 78.
Like the meaning of it, I am unable to understand 78 and 79.
That is the judgment by the.
Now, you have already stitched it. The important portions has gone with the needle.
Can I read? The 79.
Please read what you say Supreme Court did not consider. I do not. Paragraph 1 is very.
My lord, the first one is that argued before us in this regard whether the crushing of limestone by the appellant into limestone chips of desired sizes by screening amounts to manufacturing. This is the issue before the
You
Supreme
will
Court.
say the Supreme Court did not. That was the point.
That was the point. But what is the finding of the Supreme Court?
The Supreme Court.
The next argument is that the High Court caused the penalty imposed by the collector of Secretary upon appellant, taking the view that the appellant were under bona fide belief that they were not liable to pay excise duty on limestone chips. It is submitted that the High Court should have therefore also struck down the demand of
That is what I do not find, sir.
page 79.
What happened in review? What happened in review?
That
This repetition was disposed of with a categorical finding. The Supreme Court did not say that if you are arguing these points, go before and ask for a review. The review will be an answer. But the question is that the basic question is when you are converting the lump into a chip. Here in this case, this is the Sundar Sharif. that the Madhya Pradesh High Court has said that it amounts to benefits.
And my lord will ask.
And the Supreme Court has not
Interfered
interfered
with
with this.
Yes.
Then in this case also, when you are taking a lamp and you are crushing it, either to make it in a different sizes of, the stone pebbles, or making it in a powder form, it involves the manufacturing process.
My lord, I'll satisfy your lordship if your lordship will see
May
the.
not the basic characteristics of a chemical composition is not diminished or changed
My lord.
yet. With the vanishing
My
of
my lord, then my lord, your lordship and the other authorities of the Honorable Supreme Court in the case of Delhi clock for your lordship.
Our own High Court judgment.
I know that question will come from your lordships. Jagannath,
Because I was.
my lord, Jagannath Curtain, my lord.
Study council.
Jagannath Curtain.
No, we had. Judgment.
But that the. In that case, what your lordship Jagannath Curtain case. your
Jagannath
lordship-
Pathan's case was delivered by Justice D.P. M.R.PATHAK. It was confirmed by the Supreme Court.
My lord.
But DK construction is,
Beg your pardon?
DK construction, which I
DK.
was appearing and arguing the manner in which Mr. Misra is now arguing for the department.
I think it is
I
a
My lord, the
I was
definition,
assisting, standing
manufactured
sir.
definition.
my lord,
of
definition of manufacturing under the Central Excise Act and under the
manufacturing.
OVAT is totally different. Your lordship will consider that one. If your lordship will see page 49, the decision of the Honorable Supreme Court. In the case of Hyderabad Industries, their Honorable Supreme Court has held the issue was that whether the obtaining asbestos fiber from asbestos can be constituted as a manufacturing process of. Their Honorable Supreme Court, mere change of the goods when the composition, chemical composition has not been changed, or the physical condition has not been changed, then it cannot be constituted as a manufacture under the Central Excise Act.
Is there any specific definition in this act
Yes, my lord.
with regard to manufacturing
Yes.
and processing?
Yes, my lord. Kindly see your lordship if you will see page 12.
This is excellent,
Excise Act.
excellent.
If your lordship will see page 12. I've given. Page 12. Section 2.
We have the entries
Yes,
at the
I've given you.
relevant point of time.
my lord. Page 16, if your lordship will see.
My lord, if your lordship will see the definition of manufacture under the Central Excise Act, which has been provided in that compilation at page 12. Subsection F, page 12 of the compilation. Subsection F. As then, my lord, because after the amendment after 2017 GST, the manufacturer definition changed. Yes. Manufacture includes any process incidental or ancillary to completion of the manufactured product.
What is a manufactured product?
Manufactured product is the ferro product.
Ultimate,
My lord,
which is distinct in shape, which is distinct in size, which is distinct in original
my lord,
visual object.
my lord. It's original object and mere processing in
Where is the
chapter. If you are
sorry, where it says?
my lord, that has been interpreted by the Honorable Supreme Court in the case of my lord, that has been interpreted by the Honorable Supreme Court in so many cases. Your lordship see page 49. Hyderabad Industries.
Judgments. I was reading it.
My lord.
I was reading those judgments.
My lord.
So,
And the most important part is that tribunal has not considered our manufacturing process, my lord. He has only considered the
asbestos case where the import was done. It says when it is the fiber of the asbestos when separated from the parent rock, it does not come within the purview of the manufacturer. That was for the purpose of the custom duty to be levied thereupon. Though incidentally the Supreme Court says that it is not accessible. So no additional duty.
No additional duty is
that is the different case.
But the process, your lordship, whatever the
that's the only point you are.
No. The first point is that even if in
any other point,
even if two different headings, my lord, it cannot be said to be manufactured. Once the tribunal has
any other point,
the tribunal in the impugned order.
Second point, I understood. Second point
is that the tribunal has considered, though the if your lordship will see the tribunal order at page.
There, which paragraph?
Paragraph 6.2.
Yes. We have seen that. Chapter 26 is.
Chapter 26 and the notes thereon.
What you are taking, tell us, you are taking us to chapter 26.
That has come into effect in the year 2011.
So the please take in is, you are taking that once it has come into effect on from a particular date, it cannot be given a retrospective.
Retrospective.
In the point.
It cannot be given in retrospective. And here the point is that owes to concentration. And owes to concentration. Your lordship will appreciate that one. In relation to products, this chapter, the
Appreciated it if you want, we can appreciate it by giving a judgment. You are appreciated.
your lordship may admit that one, and I'll prepare more to satisfy your lordship.
The appeal is admitted on the following substantial question of law, whether the notes, whether the to find out whether you are taking this plea or not.
Questions of law, you have framed, it is not emanating.
It is always not. It is always.
These are big things.
I'm deeply obliged, your lordship.
You have never raised this.
Madam.
It is the duty of the court to frame the substantial question of law.
Not duty.
That's why we. Yes, notices.
Lordship will require to remind the lordship, I can remind you. That's shifting matter. Excessive shifting applications were there.
Give me OEL.
It's exercise.
OEL, or what is this?
Odisha Excise Act, same thing.
Oh.
Mouse to come up. Yes,
Soft got.
You were talking about section 29
Right, 29, 30,
and
35.
30,
35.
35.
It is only when a license is there, he is liable to pay. 35 is concerning duty, 29 is concerning.
That is in relation to privileged one.
Right. And 35 is concerning fee,
What?
license fee. State government may, in addition to duty levied in this act, accept payment of such sum of fees, license fee. But there are two things. In respect of a licensee, license is paying two things. One is a duty for the amount to be lifted by him, that is called excise duty, and other is a fee. For the grant of exclusive privilege, government fixes a fee for that. So two things is liable to. So your lordship.
You have relied upon Justice Susanto Chatterjee's judgment.
Right.
Privilege fee.
Privilege. Now, here we say that it is on account of a under Supreme Court's order, the shop got closed.
No, that I know. That is the 500 meter, thereafter the municipal areas where after the local bodies in
Local bodies,
that we
220 meter.
I'm conscious.
Now, finally, irrespective of any of those things, government has agreed.
And they have not charged during the period. when
1780
the
there.
Supreme Court judgment was there. for charging from 2018.
18 onwards.
Now you have already chosen an unobjectionable site.
Right. Government on principle agreed.
Agreed, unobjectionable site where you want to shift.
Not unobjectionable. They say that whatever objections are there, they will relax it. In their wisdom, they have said that. Subject to, I agree to pay from 1819 till the date. That I am agreed.
What? God. This, the challenge is made to be connection. reflected in that order.
That's
In view of the disposal of the instant repetition from the interim order, but in the instant.
Convenient. May I pray, my lords, my request is only for item 10. Lordship,
We are
rules
calling item 10. What?
item 10. As I say, I was told that they
Oh, taking a matter is there.
means that is how I made the prayer. The Lordship was not inconvenient. Subject to,
You have seen from the morning what is happening.
yes, yes. It will only take 10
Let
minutes.
us see, I do not know.
Man. Can
It's
I?
a 2 p.m. matter, so I do not know how long will it continue.
Man.
It may not. I hope so. Which matter?
Item 40.
14,
40, 40, 40.
40.
The last.
Who is appearing in 40? Who is appearing in 40? Oh, how much time will you take, Mr.
I will take some time, my lord, because I have not placed the impugned judgment as yet. And I have prepared a short notes of submissions, which perhaps will
And
assist
for the
you
other
about it.
side? No?
Deputy Solicitor General. Mr. Pari. Mr. Pari.
Mr. Pari,
Is he online? The Pari is online?
No.
Huh?
No, sir.
He should have. He might have been
any
in
C,
dilemma because of the another bench.
Yes, but
any CGC?
Who is appearing? Can you ensure the other side? What is
I'm intimate. I'm intimate.
No, Mr. Pradhan, you don't have?
a notice was given, my lord, and lordships are pleased to direct the matter to
Yes.
start at 2 p.m. Therefore, my lord, I presume that the other side had notice and therefore they should have
But
been.
because of the intervening bench. So there may be some kind of a confusion. Yes, let's call the 40. Just wait. Let us see.
Item number 40.
The last occasion I gave your lordship a background of the facts of the case. I am sure, my lord, your lordship so do not remember now exactly, but I shall recapitulate.
Absolutely correct.
And I don't, well, of course, it is not possible because of so many matters having intervened in the meantime.
Yes. What is the matter about?
Well, this was in respect of a private siding which the railways wanted to have. And I was assigned, my client was assigned with the job of constructing that. And this private siding is for the purpose of transportation of heavy iron and steel materials. So, my lord, and this is, my lord, under private-public partnership. It was to be done.
It's a PPP model.
Yes, PPA model. And when the railway didn't have any stake in the matter at all, I was to procure land. I was to, my lord, construct this. I was to lay the rails. I was to put up the signals. Entirely my cost. And in addition, my lord, I had to deposit 5 crores of rupees. Now, my lord, if your lordship asks me what for, well, I do not know. Supposed to be security. I could have understood, my lord, security is demanded from a person for the purpose of, my lord, for the purpose of protecting one's own right. But insofar as the private siding is concerned, the railways were only the beneficiaries. no stake in the matter at all. Nonetheless, my lord, I deposited this amount of money. I expended this for over 5 years. The construction had been made. And my lord, from the main broad line, there was to be a connectivity. This connection what the railway was to give after I have completed the work.
This joining with the rails of the
Indian railways, of the Indian railways. Now, this, my lord, was to be done according to the railways at the fag end. According to my client, on the basis of the documents, it was to be done along with it. So that, my lord, I know exactly how much I have to construct, what will be the point of connectivity, etc. This I was not given to know because, my lord, ultimately that land licensing agreement, which was to be executed by and between the parties, that did not come forward. Because, my lord, the land licensing agreement was not, my lord, forwarded to us by the railways. And we have been clamoring.
It was not formally executed.
It was not formally executed. So, but when this process was going on, and we had been waiting for the land licensing agreement to come forward, my lord, without any notice, without giving me a hearing, this entire project was, so to say, they said that quote unquote foreclosed. Now that was the letter which I have carried. There are 3 letters which I have impugned in this proceeding, which are one after the other. One was, my lord, purporting to foreclose. The second was purporting to, my lord, forsake my money. This 5 crores of rupees gone. And, my lord, certain amount had been paid by us by way of administrative cost. They call it nodal cost or something like that. Nodal cost. Well, that was also, well, had gone into their pocket. They have not. Now, my lord, I am questioning this purported foreclosure. I am saying that they could not have done this. And particularly without giving me a hearing, because, my lord, this
on a plea of a promissory estoppel or on a plea of the breach of the contract or what?
They said that we did not find that you were interested in proceeding with the work. When, my lord, the work was being done throughout, well, under their very nose, they knew exactly what was happening. Correspondence is there, asking for progress report, and they're asking for, my lord, the date of termination and all that. These are all there. I shall place it before your lordship. My lord, 2 issues, my lord, the learned trial judge had been pleased to pass the order. Gone into the matter. First is with regard to, my lord, the maintainability of the rate. Apparently, my lord, the government raised an issue with regard to maintainability of the rate. They said that it's a civil dispute. Therefore, the writ was not maintainable. We should have gone by way of a suit. That particular issue, my lord, had been decided in our favor. The court had said that in view of the various judgments, starting from associated engineering and all, there is no reason as to why the writ should not be maintained. So I am not troubling your lordship with that. My learned friend, perhaps if they are agreed by that, they will argue, but they have not preferred an appeal. Second issue, my lord, is with regard to our not working on that thing. And here, my lord, our submission is that the learned trial judge has gone absolutely wrong, because the facts which were on record had not been taken note of. The fact that we had worked these various progress reports which had been filed from time to time, the correspondence between the parties until the last moment, until, my lord, they were put into foreclose. All these documents were there before the court. But the court had come to the conclusion, if I may just take your lordship to that portion of the judgment. Well, I'd kindly come to page 43. The judgment starts there. If your lordship, after the facts have been stated, the letters have been, your lordship will please to come to issue number A, which is at page 51. I'm not troubling your lordship with the facts. I shall come to the facts. I shall
Oh,
I have
this
handed
has
up
gone
to-
in your favor. The issue in number A has gone in your favor.
Yes, therefore I am not troubling your lordship.
Yes.
Then, my lord, yes, kindly come to page 57. Your lordship kindly sees this just to round up this part
Can
of the-
indeed be exercised in the contractual matters involving the state. Paragraph 14, I have seen.
Yes.
No difficulty.
So, therefore, and my lord, at page 59, paragraph 16, my lord, kindly see. Then we come to issue number B. That is at page 59, bottom. Issue number B, whether the court ought to interfere in the facts of the present case.
Yes.
In the present case, this court has painstakingly gone through the mountain of communications placed by both parties. The ESP of the proposed private siding was approved on 19/11/2010, and the bridge drawings were approved on 26/2013. Construction of the private land of the proposed private siding usually commences at this stage. There is a major connectivity construction stage that marks the end of the construction, which is the construction of the takeoff portion of the proposed private siding on the railway land. Well, this is private
Where
side.
you want to the connection, the junctions
It's
where
sort
you
of
want to
goes
connect.
round and connects to the main.
Correct.
However, this stage, though major, arrives at the fag end of construction. The DPR approval letter dated 15/25/2010 contains some pertinent clauses that this court deems appropriate to reproduce here. In fact, my lord, clause 12 and 16, these are the clauses which are important, but anyway, the three clauses have been set out. The proposed private siding should be constructed wholly on private land, as no railway land will be spared for construction of private siding except the takeoff portion. Then 12. The land licensing plan incorporating the observations of DPR approval must be prepared and submitted to the railway with the engineering tracing plan for its approval. Any construction work of the siding proposed on the railway land will only be permitted after approval of land licensing plan and execution of land licensing agreement. So it has been construed this one. I shall show to you not
You only solely on a private land. In the event the railway land is intended to be used,
Yes.
then you'll have to give a license plan on the basis and the fees. Agreement to be
an
executed.
agreement, land licensing agreement. Then, my lord, siding agreement has to be entered into between the railways and Mr. Durgamur Materials, that's my client, as per extant rules and guidelines laid down by Railway Board and in the courts. You are requested to approve the Chief Commercial Manager's office for execution of siding agreement. My lord, I shall show to your lordship how many times we have approached this. Then you are requested to please submit engineering siding plan and land licensing plan. Engineering siding plan, admittedly, I have given. There is no dispute with regard to that. Land licensing plan on tracing paper along 15 ferrocopies duly incorporating all modifications suggested above for approval of the railway. This also has been given. Insofar as the railways is concerned, their contention is this agreement. After all these have been exchanged, you should wait, complete your construction, and this joining point we shall give you at the end of it. Very well. Our contention is this, that at the end, what does it mean? One has to know as to how the connectivity is to come and where at what point of time. I could have understood some reason as to why they should drag their feet. But of course, no reason had been given. Only thing is this, that they have not given us. Anyway, I shall come to that. That's one of the points, issues involved. Then kindly see. A bare perusal of clause 16 of DPR approval letter reproduced above would highlight that only construction on railway land may not be commenced before the land licensing agreement is dated. Why has the petitioner company used this as a crutch not to complete the construction of the private land portion of the project? This was the question the learned judge posed. the drawing of the proposed private siding of Durgapur Metallics between BJMD and BBN had been approved by the engineering department and registered under so and so. The land licensing plan was approved, and no dispute. Then the land licensing agreement was pending with the railway authority. Therefore, the railway authorities can be faulted for not being prompt with the land licensing agreement. That is admitted. However, there is no reason why construction was not undertaken on the private land portion of the siding for so many years. But the learned judge has proceeded on the basis, I don't know why his lordship got this impression that no work was undertaken for this private siding. In other words, for 6-7 years, I have been sitting there doing nothing. I indicated to your lordship on the last occasion that the private siding was to be constructed for the purpose of that. Well, on the two sides, the agricultural lands are there, mostly dhani jomis. Now, this has to be constructed upon. They have to be brought up to that level. For the purpose of that, compaction is required.
You have to elevate the rods for
Yes.
the purpose of the rails to be laid like that.
This has been done.
Okay.
And this report was being given from time to time. I respectfully submit that these reports were on record. Therefore, that should have been taken note of. I am, my lord, joining issue there. I am saying, my lord, what was there on record? On the basis of that, would you have come to the conclusion that the construction was not undertaken? As, my lord, as the impression I think the learned judge got, my lord, if this had been correct, then the learned judge was right. But my submission is this, that if there is evidence on record showing that construction was being undertaken, now, it's a huge construction. My lord, I have given it
1.5 miles.
1.5 miles in length and 100 meters weight. That is the sort of construction that is to be made before the rails are laid. And the signals are put up. This was being undertaken, and this is not a small work. And the one is proceeding on the basis as if one undertakes the work today, and by day after tomorrow, or day after tomorrow, the work is completed. It is not that. The work was being done, and under the railway supervision. Naturally, my lord, the railway wagons will move. Huge, heavy materials will be, my lord, loaded onto this truck. Therefore, compaction has to be very, very done. My lord, ballast, this stone chips, etc., are required. First of all, my lord, it is soil, soft soil is required. On the basis of it, my lord, the ballasts are put, then my lord, stone chips are put, and my lord, it has to be a solid land. Though this was being undertaken, this was being constructed, and from time to time, my lord, the railways had been asking us, give the progress report. Progress reports were given, photographs were given. The railways are coming over there, Bosho. Railways were coming there, railway people, engineers coming there, watching, my lord, what is being done. And there is not one letter. I was, my lord, searching for one letter, at least, my lord, to be annexed to the affidavit in opposition, the counter affidavit, saying that, why is it that you are not working? Why is it a delay, Darren? Why is it there is so much of delay? Not one letter. On the contrary, my lord, progress reports are being asked for, and every progress report I am writing, give me the land licensing agreement. We know exactly the constructions which will ultimately to be made. Construction was complete, the foreclosure came. Anyway, this is the portion joining issue, my lord. I'm submitting to your lordship that perhaps it is not correct. The basis of the facts which are on record. And as I said, there is no reason for why construction was not undertaken on the private land portion of the siding for so many years. My lord, I would expect, my lord, the railways, if my lord had not undertaken this, work, then the railways would have written not one, numerous letters. They would say, what have you been doing, dragging your feet? Why is it that you are not proceeding with the matter? Then, my lord, chronology of events clearly establishes that the petitioner had ample opportunity and time to proceed with the construction on its own private land. I am not going into the railway land at all. I could have understood, my lord, I am going onto the railway land. I am not proceeding with the work expeditiously. The railways, my lord, taking umbrage on that. It is not that on the construction on its own private land. And my lord, I just asked this question to myself that, my lord, what possible reason can be after spending, my lord, crores of rupees for the purpose of procuring this land, I will be sitting doing nothing. And the railways will also, my lord, sit quietly. Then, my lord, with the detailed project report, DPR, approval as early as 25/1/2010 and subsequent approval of the ESP on 19/11/2010 and the bridge drawings on 26/2030, there remain no substantial impediment to initiate and proceed with the construction of the private siding on non-railway land. I was just, my lord, thinking that for the purpose of construction of a multi-story building, how long does it take? It takes years. It is not done, my lord, particularly nowadays, the huge buildings which are coming up. They take 5, 10, 15 years for the purpose of construction of it. Because, my lord, one has to have the foundation done properly. And thereafter, my lord, this it is almost built on a stilt for the purpose of holding this the structure which will be there. And here in this particular case, movement of railways. So, my lord, it has to be done properly. And we had undertaken the work and we had been doing the work. Then, my lord, it says clause 1 of DPR approval categorically notes that the private siding is to be constructed wholly on private land. Therefore, my lord, the railway has got no stake in the matter at all. It is private land. I have personally procured, and, my lord, I have spent money on that. On that, my lord, the construction is being made, save for the takeoff portion. So, my lord, only the takeoff portion the railways are interested in. Thus, the petitioner's failure to utilize over a decade's time to carry forward its own share of construction, despite clearance and instructions, cannot be justified. The consistent inaction. These are the portions where I have taken exception. The consistent inaction points to either a lack of genuine commercial interest or an intent to delay execution, undermining the purpose of the project. Again, I pause here for a moment. Admitted position is this, that my client carries on business of manufacture of beams, huge beams which hold the ceiling, the pillars, the joists, the sheds, and these are huge things which are being transported by railway wagons. The interest of my client is this: if there is a siding, private siding constructed by my client, then it will do, my lord, it will ease the business dealings for him. But private siding will be utilized by him. That is the interest of my client. Therefore, my lord, my client would not be sitting there idly, just, my lord, wasting time, when, my lord, that amount of money had been spent for the purpose of construction of the. This, my lord, this perhaps the learned judge, could not be impressed upon the learned judge.
What swayed the mind was that since the contract was granted back in 2010.
Yes.
In 2015, more than 1.5 decade has already expired. Still no substantial things or constructions have come up. So that was the reason the learned single judge was so much showed his concern.
I am sure, my lord, the learned judge had justification for putting the question. My submission is this: before coming to a conclusion with regard to inaction, perhaps, my lord, the question should have
did not take into consideration the several letters exchanged between the parties, the progress report
no complaint at any point of time. And
report having submitted, not a single query
not a single
was
query.
raised on
Not
your,
a single
on
query.
your dilly-dally or whatever, the reluctance to continue with this.
And this is the surprising thing. For 10 years, I am sitting on a thing, and the railways, who is also interested in my construction, even though they don't have any stake in the matter, they are sitting there. That factor has a. Then, my lord, kindly see this. If this is the consistent inaction points to either a lack of genuine commercial interest or an intent to delay execution, undermining the purpose of the project. In a scheme where the railway's involvement is limited, the learned judge is taking note of that fact. This is the correct thing. Where the railway's involvement is limited to providing access through the takeoff portion, the petitioner's inaction on private land construction cannot be glossed over. This prolonged inaction militates against any claim of arbitrariness in the withdrawal of administrative support and certainly does not warrant intervention under Article 226 of the Constitution of India. The withdrawal of permission by the railway authorities cannot be characterized as arbitrary or unreasonable. It is arbitrary and unreasonable for two reasons, my lord. I have pointed out. First is, my lord, there was no material on the basis of which this conclusion could have been drawn. Secondly, and this is most important, time was never the essence of the contract. And if time was not of the essence, then before termination, it was absolutely incumbent upon, my lord, the railways to make time essence of the contract under Section 55 of the Indian contract. And thereafter put an end to it. That means saying that look, I am giving you 3 months' time, complete the work. Otherwise, I am going to put an end to it. Such kind of documents were to be there before the court. And I was, my lord, frantically looking for one letter at least, an extra affidavit in opposition of the counter affidavit saying so. Nothing was forthcoming. So, my lord, this finding, my lord, I submit to your lordship, perhaps cannot be justified. Clause 12 of the DPR letter mandates construction of on railway land may commence only after the land licensing plan is approved and a formal agreement is executed. However, this stipulation does not restrict or bar construction activities on the petitioner's own private land. This is correct. It does not bar. But, my lord, this particular construction of the DPR, perhaps, my lord, I will be able to show to your lordship, may not be correct, because subsequent letter, including the letter written by them, they are saying that, my lord, this agreement, land licensing agreement, was to be constructed before you undertake the work of on private land. I am saying that I did not wait for them to give me the land licensing agreement. I was carrying on with the work. But that cannot be a justification for putting an end to the work. This is one of the points I have taken. However, this stipulation does not restrict the bar of construction activities on the petitioner's own private land. The railway had approved the relevant drawings and communicated the process forward. The petitioner's reliance on the pending land licensing agreement to justify its total inactivity ignores the project structure itself. But I will agree with the learned judge with the greatest of deference that had there been total inactivity, then the railways are justified in terminating it. But the issue is, was there total inactivity? From the documents, come to the conclusion that is so. If not, then, my lord, finding of fact on the basis of which you are justifying the railways taking this arbitrary action. My lord, that cannot be justified. My lord, action becomes arbitrary if it is without any reason. I say it is without any reason because the reason which you have put forward to foreclose is not justified on the facts of the case. And factually, that is so. Secondly, this is another point we have taken, that they have relied upon a clause, one clause 2.4 in a freight marketing notifications.
Circulars.
Circulars. And that
freight marketing
2.4, my lord, is not applicable in our case. So there is another act of arbitrariness on the part of the railways. That point had been taken specifically in the in my writ petition, but that had not been considered by the judge. So these are the infirmities which I have pointed out in my writ petition and in my submissions I want to highlight. In fact, my lord, I have prepared a short notes of submission giving my lord the points, first of all, the factual basis, admitted facts without any controversy. And my lord, on the basis of that, I have given 5 reasons as to why the activity of the railways could not be justified, and therefore, my lord, this judgment could not be sustained. Lord, my lord, I find that are you appearing for this?
Yes.
The lordship is appearing on behalf of the DSGA as he is unveiled the lordship, and he'll be appearing on the next date. I have taken all the notes, your lordship. Lordship will keep it to any other date.
No, I have not finished. I have not concluded this, my submission. Let me conclude my submission.
Many failure.
Yes, your lordship.
When failure.
Lordship. Today, I had the instruction to appear at the lordship. Give something.
You ought to have communicated this fact before.
You were fortnight back. Your lordship had pleased to fix the matter for me.
You can't predict so far as a health point is concerned.
No, I am not.
Nobody can predict.
No, but
we ought to have said much earlier. He is not feeling well since
well, I
last morning. You would not have come.
Lordship, I only got to know today only.
will you be able to argue tomorrow? Or it's too short a time?
Too short. Next week, any date.
Anyhow, you complete.
Yes.
He is taking note.
I'll take
He has been instructed to take note of.
Yes.
Then, my lord, kindly see the next sentence. Continued reservation of railway resources, land and administrative time for a party that has not fulfilled its basic obligations cannot be justified. I pause here for a moment. Every word I am challenging. Continued reservation of railway resources. I just asked this question, what resources the railway has? Railway has not spent a farthing. On the work that I have undertaken, railway had no stake whatsoever. Railway stake comes in only when, my lord, I come to the connecting point. That is the land licensing agreement. From that time onward, the railway did not undertake any responsibility. This is the other way around. The railway did not take any responsibility in respect of this because they did not come forward with land licensing agreement. They shared their responsibility. This is my submission before lordship, and this has not been taken note of. I would just like continued reservation of railway resources. Land. Which land? I have not gone into the railway land at all. I was not allowed to go into the railway land. And administrative time. Well, I am constructing this, coming and looking into the matter for their own benefit because they are getting an additional siding. And getting a siding means, my lord, huge amount on account of freight. If the siding had been constructed and the wagons had been moved on that particular area, then, my lord, the amount of freight the railways would have been earned, my lord, this is mind-boggling. And there are sidings one after the other, side by side. All the steel company, my lord, this particular area is, my lord, coal-rich area. And coal-rich area. And, my lord, as a consequence of it, my lord, the businessmen, the industrials have come from different parts of it for the purpose of setting up their industries. Mainly, my lord, iron and steel industries. And for the purpose of that, the movement is very much required. And of course, today, the transport is competing with railways, but railways cannot be beaten because, my lord, quantum of materials that are transported by railway in one set of wagons, that is much more than, my lord, 50
Several trucks.
So therefore, my lord, this is real for the purpose of benefit of the mutual benefit. I will not say it is railways benefit. It is mutual benefit. If I did not have the benefit, why should I spend that amount of money? Of course, I would have profited from it. But railways also. But then again, because of this private-public partnership, the railways did not have to spend any money. I have undertaken the work. I am going to spend money on procuring my private land. I am spending money for the purpose of construction of the siding itself, laying the rails, setting up the signals and all that, under the supervision of the railways, of course. Nothing can be done without their supervision. They are breathing down my neck all the time. They are looking into what I am doing. Therefore, when they are doing that, and I am not doing anything, then the railways should have come forward. In this backdrop, the railways' decision to revoke the project-related permissions emerges not only as lawful but also reasonable and reflective of their duty to safeguard public interest and avoid dead capital lock-in. My capital is being locked in. So railways capital has gone public interest and avoid dead capital lock-in. I don't know where this just get it from. It is well settled principle that the High Court, while exercising jurisdiction under Article 226, does not sit as an appellate forum. Does not sit as an appellate forum in contractual or administrative disputes unless there is manifest illegality or arbitrariness. The case at hand does not involve any statutory breach by the railways, but centers on petitioner's failure to perform its contractual or procedural obligations. The project never matured into a binding commitment due to the petition. The case at hand does not involve any statutory breach by the railways, but centers on the petitioner's failure to perform its contractual or procedural obligations. The project never matured into a binding commitment due to petitioner's prolonged non-performance. The railway merely withdrew permission in response to this inactivity after providing several years of opportunity. The court cannot substitute its judgment over the administrative discretion of expert authorities, particularly when no constitutional or legal violation is demonstrated. I say it is constitutional violation because it is arbitrary, violation of the principles of natural justice, violation of Article 21 of the Constitution, violation of Article 14 of the Constitution, and legal remedies because violate the contractual provisions of the contract. You cannot terminate a contract or an obligation. I'd like to put it this way: an obligation which I have undertaken at your instance without giving me at least a reasonable time to rectify me. They should have come and said that I'm giving you 15 days time, 1 month's time, 2 months' time. You complete the work. Without doing that, you just say that I foreclose. And whatever has happened in the meantime, what will happen to the, I'm asking this question to myself. What am I going to do with this land? Build a house by the side of the railway track. 1.5 mile long, this place. Huge area for the purpose of the wagons to come in and go. I am see what has happened to me, the prejudice that I am suffering. I am landed up with this quantity of land. I have condemned myself to my lord fill it up, which was a lying low land. I filled it up. I have spent huge amount of money on that. I have purchased, my lord, the rails. The rails are lying over there. I'm in my progress reports. I have said so. The rails are lying over there. Slippers are lying over there. My lord, signal material lying over there. They are, my lord, rotting in the rains. I have spent that amount of money. And what about my 5 crores? 5 crores, my lord, they have taken by way of deposit. And I first question I asked my client, what for this amount has been taken? He could not give any answer. Amount has been taken, 16 lakhs of rupees had been taken by way of administrative cost. What administrative cost? Whose administrative cost? When you are not involved as if, because the linking has not taken place. If this is not arbitrary action, then I don't know what is that action. But after all, this is a private-public partnership. You have taken me in confidence to do the work. I have taken you as confidence as my employer for the purpose of overseeing the work. You don't discharge your duties. You say that I'm pocketing the money. You do whatever you like with that amount of land, quantity of land. And what I repeatedly submit to your lordship, that the railways do not have any stake in the matter so far. If they have one extra siding, then they would have earned freight. Perhaps they are not interested because they are earning freight elsewhere, big amount of money. So their stake is not there. I have sunk my money and I don't know how to retrieve it. The railway merely withdrew the permission in response to this inactivity after providing several years of opportunity. The court cannot substitute its judgment over the administrative discretion of expert authorities, particularly when no constitutional or legal violation is demonstrated. My lord, my submission is this. Had I, my lord, opted for railway land, then railway would have had stake. Then, my lord, they could have turned around and said that, look, you are holding up my land. If you had not taken, I would have definitely given it to X, Y, or Z. They would have done the work. They can't say that. They don't have any stake in the matter. Yes. A writ court does not enforce contractual obligations unless statutory rights are implicated. Here, the grievance essentially relates to the consequence of the petitioner's own non-action, and the relief sought would effectively compel the railway to continue with a dormant proposal. Somehow, my lord, the learned judge got the impression that for 7-8 years, I have been sitting over it. I am not doing anything. I think, my lord, that is the impression the learned judge. That is why, my lord, this judgment has 15 years was the. Yes, 15 years. Not 15 years, really.
2010, you got the sanction of the site.
And 2017.
15.
7 years.
No, 15. Not 25, we are in 25.
No, 2000. 2007 to 2007.
2007.
2000.
BPR was in 2007. Then it got approved.
And in 2017, they put an end to it. 9 years, I say so.
Oh, yes, that's true. 2010 or 2013, whatever. And 17.
Answer 25. Answer 25.
Now 8 years have also elapsed.
Yes, thereafter. Will your lordship be surprised to know? They took 4 years to file their affidavit in opposition. I've been crying myself forth. The public complaints of laws delay. Kindly, ask your my learned friend as to who is responsible for this thing. Public, clamor for the quick disposal. But if the government is not quick, then who can do it? 4 years they took for filing their affidavit in opposition. I have said so in my affidavit. That is on record. And they are saying that you have been sitting over the land. Next paragraph is very important. Kindly see para 23. The railway authorities are responsible for judicious allocations and monitoring of limited public land. Where did public land come in? And infrastructures. No public land involved, no infrastructures involved.
What he meant is that you cannot dissect yourself from the public. You are also part of the public.
No, not public land. It's a private land. I have procured.
If you are owning it, if you are a part of the public, then yes,
If I am a part of the public and I have invested on private land for the purpose of setting it up, your lordship can your lordship think as to one reason as to why I shall be dragging my feet, as to why I shall deliberately delay. My money is blocked up. My 5 crores is blocked up. The amount of money I have invested in the land, procuring my lord ballast, sand. But these are my money has been.
Got it.
So therefore, my lord, when it says judicious allocation and monitoring of limited public land and infrastructure, I will put my question here as to what is the public land and where is the infrastructure, public infrastructure. Holding these resources definitely, for a private party that has shown no proactive engagement undermines public interest and planning. Had this been correct, this would have been so. This is entirely erroneous in my observation. The land licensing agreement, though pending, was contingent on the petitioner complying with prior procedural steps. In the absence of genuine progress, again, where the learned judge is getting this from, I do not know. Because the party who should have complained did not complain. The learned judge is complaining about it. The land licensing agreement, though pending, was contingent on petitioners complying with the prior procedural steps. In the absence of genuine progress, the private land construction, there was no rationale to press forward with the railway site execution. The railway cannot be faulted for deciding to keep the permission alive in a vacuum. Continuing its permission without parallel commitment from continuing with such permission without parallel commitment from private party creates administrative bottlenecks and skews the infrastructure planning. This court in which jurisdiction is not micromanage such policy level decisions unless a clear breach of law is shown, which is absent here. This court therefore finds no merit in the petitioner's argument for arbitrariness and declines to exercise strict jurisdiction. The administrative decision of the railways is proportionate, contextually justified, and based on sound reasoning aligned with public interest. But I wish, my lord, that railways have been justified in getting this certificate. This is a glowing certificate given to the railways. I am sure, my lord, they will be very happy to receive it. This court therefore finds no merit in the opinion. The administrative decision of the railways is proportionate, contextually justified, and based on sound reasons aligned with public interest. The conclusion is keeping in mind the aforesaid principle and considering the arguments of the respective party, this court will review the facts of the present case.
That's the ultimate decision matter.
My lord, your lordship will see. Kindly take my writ petition once. I just want to draw your lordship's attention to the paragraphs in which I said what I am submitting to your lordship, and that has not been considered.
That we understood. You say we understood that this is what your case is. If I summarize the entire argument which you are advancing, is that definitely it is a PPP model where the railway decided to provide a private siding so that they can use and utilize that particular facilities. The agreement was entered into, you purchased this large chunk of land. You started making constructions, whatever in order to facilitate this particular, the siding to function. And so far as the joining portion is concerned, when you reach to a railway land, when you join, the two things are there. One is the plan, another is an agreement which is seen upon onto it. This stage will come when you have completed the entire work.
Right.
You were doing the work after it was entrusted to you. They were asking for a progress report. They were making a periodical inspections. They were going there. There was not a single query which was raised to you regarding the slow pace of the work or the inferior quality of the work or any of that kind, nor there was any demand that you'll have to complete the entire project within the time frame what is there. Since the time being not the essence of the contract, so there was no obligation in this part. Now, second, the thing is that when everything was going on, suddenly one fine morning, they say that I hereby foreclose the agreement without assigning any reasons therefore. There was not even a single demand which was raised or any contemplations to remedy whatever the defects which they have found. They have not noticed any kind of a breach of the terms and conditions. Nothing has been done. Abruptly when they jump, that amounts to an arbitrary action. And in absence of anything, they cannot come forward and foreclose the agreement which is against the contractual obligations. And contract act also does not provide in that sense. The observation of the learned judge appears to be default the record because he has not taken into consideration the several documents which were already annexed to the resolution, showing that the progress report there, you were already communicating with them, everything you were letting them know. These documents were not taken into consideration. These are the findings which can be at best be said to be perverse in the sense that based on either no material or non-consideration of the vital piece of an evidence which is already there. So these are one of the instances of the perversity that would come.
Absolutely.
So that is what you say that this judgment cannot stand.
Your Lordship has been pleased to very admirably summarize my submissions. I am very grateful to Your Lordship. And this is exactly what I wanted to submit to Your Lordship. And what I wanted to also show to Your Lordship that it is not something I was picking out from the air and making the submission before the trial court. These were there.
There is a foundation.
There is a foundation in my writ petition. I just wanted to show to Your Lordship. Kindly may not come to page 82. A part of the display. Kindly may not take my. Just by way of interest, I am showing to Your Lordship. After my Lord giving the facts of the case, almost like history. My Lord, kindly come to page 82. Paragraph 3.14 of the petition, writ petition.
No, of the writ petition.
Of the writ petition on which manner this order was passed. This is manner at page 82 of the paper.
82 of the writ petition or
No. Page 13 of the writ petition. 1-3.
1-3 of the writ petition.
1-3.
You go and open the writ petition.
Your Lordship does have a paper book like this, which has been filed.
Yeah, paper, yes, sir.
Well, that is what the Supreme Court also said. Justice General
May I put this particular word prefixing, not suffixing? We have less paper book.
Well, I
completely not erase the papers, but less paper.
But it was a pleasant experience for me coming from Calcutta. That Your Lordship's courts are much cleaner. Then, my Lord, the courts Your Lordship had been pleased to sit earlier. My Lord, there, the piles of papers, my Lord, almost the council, my Lord, hide behind the papers at the time of making submissions.
That is.
Report 1-3 you are referring?
Yes, page 1-3, 13 of the.
13.
Yeah. para 3.14. Yes, your lordship is perfectly right.